As we transition from statutory disclosure requirements and environmental hazards like radon and lead, we now enter one of the most litigated and misunderstood issues in real estate: mold. Unlike lead-based paint, which is governed by strict federal law, mold operates in a gray area of disclosure, liability, and professional judgment. This makes mold one of the most dangerous risks for real estate professionals, not because it is always severe, but because it is often underestimated. Mold is a natural and necessary part of the environment, but inside a home, it becomes a potential health hazard and a legal issue. Its primary function in nature is to break down organic materials such as wood and leaves. However, when mold develops indoors, it can produce allergens, irritants, and in some cases toxic substances known as mycotoxins. These can lead to symptoms ranging from mild allergic reactions to serious respiratory issues and, in extreme cases, severe health complications. This is where the legal issue begins to take shape. Under AAC R4 28-1101, agents are required to disclose known material facts that could affect a buyer's decision. Mold, depending on its severity and location, can absolutely meet the definition of a material fact. This ties directly back to Hill v. Jones, 1986, which established that sellers and agents must disclose conditions that are not readily observable, but materially impact the property. One of the most important characteristics of mold is that it cannot grow without moisture. This simple principle becomes the foundation for both identifying risk and preventing future issues. Mold spores exist everywhere and are not visible to the naked eye. When they land on a moist surface, especially one made of organic material, they begin to grow. This means that mold is not just a surface problem, it is almost always a symptom of an underlying moisture issue. Modern construction practices have increased the likelihood of mold growth in residential properties. Homes built after the 1970s are more airtight due to improved insulation and energy efficiency standards. While this improves energy performance, it also reduces natural airflow, creating environments where moisture can accumulate. Additionally, the increased use of paper-based materials such as drywall provides an ideal surface for mold growth. In other words, newer homes are not immune. They may actually be more susceptible under the right conditions. Understanding the causes of mold is critical for both prevention and disclosure. Common sources include construction defects, leaky roofs, damp crawl spaces, poor ventilation, high humidity, plumbing leaks, appliance malfunctions, overwatering plants, and even pet doors. Each of these conditions introduces moisture into the home, creating the perfect environment for mold to develop. From a transaction standpoint, these are not just maintenance issues. They are red flags that require attention and potential disclosure. Consider a real-world example. A seller notices a small area of discoloration in a bathroom, but cleans it with bleach before listing the property. The underlying issue, a slow plumbing leak, remains unresolved. After closing, the buyer discovers extensive mold growth behind the wall. At this point, the issue shifts from a maintenance problem to a legal dispute, where the question becomes whether the seller and agent knew or should have known about the condition. Arizona case law and common law principles reinforce that failure to disclose known mold issues can create liability. Even if the mold itself was not fully visible, knowledge of recurring moisture problems can trigger a duty to disclose. As reinforced in Jennings v. Lee, 1969, the agent's fiduciary duty requires full transparency and protection of the client's interests, which includes advising on potential risks. Another critical point is that mold remediation is not always a permanent solution if the source of moisture is not addressed. Cleaning visible mold without correcting the underlying cause will often result in recurrence. This creates ongoing liability risks, particularly if a seller attempts to conceal the issue rather than resolve it properly. From a professional standpoint, agents must walk a careful line. They are not mold experts and should not diagnose or confirm mold conditions. However, they are expected to recognize warning signs, recommend professional inspections, and ensure proper disclosure of known issues. This aligns with ADRI guidance and the duty to recommend expert assistance when matters fall outside the agent's expertise. As we move into the next section, we will expand beyond environmental hazards into broader legal issues, including fraud, misrepresentation, and predatory practices. The lessons from mold apply directly. Failure to disclose, minimize, or properly address risks can quickly escalate into legal disputes. In today's real estate environment, what really matters is not just identifying problems, but managing them correctly. Online discussion. Why is mold considered a legal issue rather than just a property condition issue? Answer: because mold can impact health, property value, and habitability, making it a material fact that must be disclosed under AAC R428-1101 and common law principles. Why is eliminating the moisture source more important than removing visible mold? Answer: mold will return if moisture is still present. Addressing the root cause prevents recurrence and reduces long-term liability risks. What is the agent's responsibility when mold is suspected but not confirmed? Answer: the agent should recommend professional inspection and avoid making expert conclusions while ensuring that any known conditions are properly disclosed.